Baldwin, can you provide any comment?
Journalism, it's time for you guys to start being journalists.
Oh, that was attorney Andrew Baldwin right after Indiana Judge Fran Gall formally disqualified Baldwin and attorney Brad Rosie from Richard Allen's case. Baldwin and Rosie originally withdrew from the case after that in-chambers meeting. Remember that one back on October 19th? And then they later walked back their withdrawal and then offered to represent Richard Allen pro bono. Well, the judge denied that request, appointing new attorneys. And in her decision, she cited her finding of gross negligence, said she found gross negligence. Now, we don't know what the parties discussed during that closed-door in-chambers meeting, but we do know it all stems from that leak of the crime scene photographs. And since then, some third-party attorneys have stepped in and filed a motion on behalf of Richard Allen. Essentially, it's called a friend of the court brief, petitioning the Indiana State Supreme Court to reinstate that first defense team. So now, as a result, the state Supreme Court has issued an order, reading in part, relator, so these relators are the friend of the courts, these attorneys, relator by counsel respectfully requests that this honorable court order that the following transcript be prepared. The in-chambers proceeding held on October 19th, 2023. The deadline to produce that transcript is November 27th. So the high court in Indiana is telling the trial court judge who's presiding over Richard Allen's case that she's gotta issue the order of that transcript. We know there was a court reporter typing away, taking down that conversation in chambers, and the judge refused to give it to these petitioners who filed that friend of the court brief. And so now the Supreme Court saying, you got till the end of the month to do it. So we're going to see what was said in that meeting. These attorneys said that they were strong-armed, given what they've said is a Hobson's choice, said that, well, you either withdraw or you withdraw, or I will publicly reprimand you and you'll be embarrassed here. So that's where things stand. And also in that brief, there are two other outstanding questions. These friend of the court attorneys want the judge to recuse herself from the case. They also want Brad Rosie and Andrew Baldwin reinstated. So right now, they're currently not Richard Allen's attorneys, but Richard Allen has indicated he wants them to represent him. So what should happen here? Let's bring in our think tank and talk all about it. Still with me, attorneys Eklund Mercy, Nima Rahmani, and Kirk Nurmi. Okay. Let's take this question by question. Let's talk about the representation question, because this one is an interesting one, with those attorneys being court-appointed initially, but then saying, look, we'll go pro bono on this one. So right now, Richard Allen currently has court-appointed attorneys, but he wants these first two. Eklund, what should the Supreme Court do on this? Should they remove the two current attorneys and reinstate the first two?
Yes. That's what they should do. Absolutely. I think that what ends up happening, I think that they withdrew initially to protect the client, and it happens often. It's best to withdraw and then evaluate versus being pushed out and putting your client in a position in which putting your client in a position that will be harmful to him. I think that that's what they did initially, and that once they reevaluated their position, they asked to get back on the case, and that was when they had issues with the judge. For a new pair of attorneys to come in and say that, hey, reinstate the first pair, it's unheard of, and I think that the Supreme Court should follow suit.
Eklund, appreciate it. Now to another question. What to do about the judge hearing the case, right? She's not recusing herself. In this friend of the court brief, these attorneys are really pushing for her to recuse herself and saying to the Supreme Court, you remove her. If she's unwilling to do it, take her off the case. Nima Rahmani, let's talk about this legally. First question, can the Indiana Supreme Court do that? And should the court do that?
Well, the issue of disqualification, I don't think that we're there yet. Judges make wrong rulings all the time, and that doesn't get them removed from the case. But I do believe that this was a wrong ruling. First of all, I mean, the transcript has to be prepared. We don't have We have in-chambers proceedings, but on appeal, if there's an attorney-client privilege issue or, Marsden hearing or something like that, then that can be under seal. But the Court of Appeal has an absolute right to know what happened. But this is the issue I have with the judge. She made a big mistake. You can't call the attorneys grossly negligent without having some sort of full-blown evidentiary hearing and finding that they were grossly negligent. The problem in this case is there's either a potential conflict or an actual conflict. And Richard Allen has a malpractice claim against his lawyers. They're responsible for the leak. Doesn't matter if someone unauthorized got in and accessed it or is one of their employees. The buck stops with them. So because there's a potential conflict, you want to avoid any issue, and that's why you disqualify the lawyers. You don't come out and say that they're negligent when the evidence isn't there. The disqualification of the lawyers is based on the conflict, and that's what she should have based her ruling on, and she didn't, and that's why she made a mistake.
Nima, appreciate it. Let's talk about that further. Kirk Nurmi, help us out here. So the judge, according to the attorneys, gave them Hobson's choice and said, hey, look, you either withdraw or you're going to get a public tongue lashing by me. You're going to be real embarrassed in this public courtroom where the cameras are watching. And they essentially are saying they felt powerless here, that she is saying, look, I made this finding without the hearing, as Nima pointed out quite astutely. I think that's really going to come back to haunt her. If the judge did that, Kirk, how improper is that for a judge to say, I'm removing you attorneys? Wouldn't sanctions for the attorneys, if the judge really found that they did something that was in contempt of court, wouldn't sanctions be the proper action by the trial judge versus out and out removal?
Yeah, that's a hard question to answer right now, Julie, because we really don't know what this finding of impropriety in the defense attorneys is based on, right? We know it's behind chambers, and that's why the Supreme Court has the right to a transcript. But let's keep in mind, Julie, this is a death penalty case. If I'm the state of Indiana, if I'm the prosecutor, I'm supporting the defense in this motion, because what has this judge done? She has interfered with the client's Sixth Amendment right to counsel, and that carries not only at the trial phase but at the mitigation phase. 50% of death verdicts, death sentences, are overturned because of improper counsel, what have you, at the mitigation phase. Mr. Allen goes in years later and says, I didn't trust my attorneys, they weren't the attorneys I wanted, and it's very likely that an appellate court, be it at the federal level or wherever, will overturn that death sentence. Likewise, you add to that the possibility that he is not getting a fair trial from a judge who is tainted, who took extraordinary steps to remove the counsel of his choice from his case. That death sentence equally, I don't think, would stand. So if I'm the prosecutor, I'm supporting the defense in this, and I want the light of day exposed on all of this, and I'm probably asking for a new judge as well.
Appreciate that, Kirk. Excellent points. So in terms of whether or not this affects his defense, I'm curious what you all think about that, because he's cloaked in the presumption of innocence, and we know his first two attorneys were very rigorous in developing their legal theory by way of motions, getting it out there. It was slick what they did. They got it out there to the public by putting it in the various motions. They know all of us are checking the dockets every day. We read through them. We dissect them here on this program and on our other programs on Court TV. And now with these other attorneys, I wonder, does it hurt things at all for him? Eklund, back to you, please.
Yes. I do think so. I think that I've had cases ripped from me. Either things happen, and when you have a theory, when you have a working theory, when you have a plan of attack, when everybody is on the same accord, and here it seems like they actually believe their client. It's all like it's just kismet, and for them to be court appointed, and for them to be so passionate about the defense, it's something that we cannot, we cannot diminish. And I really think that they are really fighting for their client. And I believe that in order for justice to be served, the client needs to have the protections of the Constitution procedurally, as well as, all his other rights. So I think that the attorneys definitely need to get back on the board. And I really don't see a way a judge, I honestly don't see what the judge was thinking in this case. And especially it being so publicized, why she would do that. So I don't know. I don't know.
Right, Eklund. That was another thing that was somewhat troubling is we had cameras in on that date where the bombshell, was dropped with all of a sudden they're withdrawing and everybody's going, why in the world? And the Allen family was upset, and our Matt Johnson reporting how Richard Allen's wife is in tears in the courtroom, and it was just chaos. But then at the next hearing a couple days later, no cameras. The judge didn't permit them in, so certainly we wanted to see what was going on that October 31st hearing date, where the new lawyers are stepping in. So hopefully our cameras will be permitted in for all of these upcoming hearings. And on November 27th, that transcript has to be turned over, so we'll see.